For you is my motion dated 9th June 2025. I have filed submissions respect of that motion. The submissions are dated 23rd of June 2025. There are 4 questions upon which we seek determination in this motion. On the first question, whether the petition filed by the first petitioner, Lady Justice Martha Koome, should be assigned to someone else. I mean, the bench to hear that petition should be a bench assigned by someone else other than the petitioner. It is not in dispute that the petitioner, Lady Justice Martha Koome, is the one who appointed this bench to hear this matter. The question arises whether a party to a petition, even if that party is the Chief Justice, can assign judges to hear a petition. The starting point in the case of Rigathi Gachagua versus the National Assembly. And in this decision, which you'll find at page 123 of the exhibits to the motion. This is what the Court of Appeal stated. So, what is to happen when the Chief Justice is, for whatever reason, absent physically or temporarily incapacitated, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party, or substantially relates to the office or person of the Chief Justice. Whereas the Court of Appeal did not give an answer to that question, the Court of Appeal affirmed that the decision in Leila Conchela, where Chief Justice David Maraga had delegated the duty of empaneling a bench of judges to hear, was the guiding factor. It is therefore our humble submission that, being the first petition in this matter, the prudent course for the Chief Justice was to delegate the function of appointing judges to hear a petition to the Deputy Chief Justice. That answers question number 1. Question number 2, whether the rest of the other 6 petitions should be heard by judges other than those assigned by the first petitioner, Honorable Lady Justice Martha Koome. It is not in dispute that my Lords Honorable Justice Lawrence Mugambe and Honorable Justice Bahati Mamwe were both appointed to the office of judge in an interview presided over by the first petitioner, Lady Justice Martha Koome, as chair of the Judicial Service Commission. Of course, judges decide matters based upon facts and the law. There is no dispute about it. That's notwithstanding, there's also no dispute that perception of impropriety ought not to be entertained where there is legitimate fear for the same. And the guiding case on this principle is Republic versus Sussex Justices. We have extracted it at paragraph 18 of our submissions. This is what the court said.
Where is it on the list number?
On the list of authorities, Sussex appears as authority number 9 in the listing bundle. In the submissions, we have extracted it at paragraph 18. This is what was said in Republic versus Sussex. But while that is so, a long line of cases shows that it is not merely for some importance, but it is for fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. It is therefore imperative to ask whether justice will be seen to have been done when two judges hearing the petition were judges appointed by the first petitioner. And this issue is not new. It has been the subject of litigation in other jurisdictions. In the case of the matter of the Chief Justice of Gibraltar, which we have extracted at paragraph 21 of our submissions.
And listed number?
The case of, it appears as number 12 in our listed bundle of authorities. Intriguingly, the Chief Justice of Gibraltar in that matter was a judge of the High Court at one point in time here, Justice Schofield. Schofield faced a petition for his removal before the equivalent of the Judicial Service Commission in that country. What he did was to file a suit before the High Court, and in that country it's only High Court judges, and sought to stop the process for his removal. It was determined by the tribunal constituted to remove him with the affirmation of the Privy Council as follows. The tribunal was correct to hold that the action of the Chief Justice in bringing the judicial review proceedings constituted misbehavior. So it's our premise that it is misbehavior for the first petitioner, Honorable Lady Justice Martha Koome, to come before a court subordinate to her as the President of the Supreme Court and subordinate to her as the Chair of the Judicial Service Commission and seek relief before that court. It is even egregious for the first petitioner, Honorable Lady Justice Martha Koome, not to see the impropriety of empaneling a bench to hear the petition. Still on the Rigathi Gachagua case, which applies in that regard, the question is this: is the bench as constituted fit for purposes of the criteria set out in law for a paneling of a bench? This is what was stated in the Rigathi Gachagua case. But the following must be taken into consideration when empaneling a bench: the expertise and specialization in the relevant area of law of a judge, judicial seniority, and with tremendous respect, much as I'm mindful of Bat versus Rent Restriction Tribunal, that any judge, whatever the age of appointment, is fit to hear the matter. These are the words of the Court of Appeal. judicial seniority and experience, the need for balance and diversity of perspectives, often achieved by selecting judges in varied legal philosophies, regional representation, or professional backgrounds, any prior involvement in related matters, the sensitivity of the case, and the corresponding need to uphold public confidence in the judiciary, avoidance of conflict of interest to ensure impartiality. My lords, FIDA have just been here. This bench is fully male. It's fully male. There's a problem. There's a problem. Where is the female gender in this bench? It doesn't meet the test set out in the Constitution and the Court of Appeal. Where is the consideration of judicial seniority? I handled Philomena Mwilu versus DPP, and all the 5 judges of the High Court empaneled to hear that matter were peers of the Deputy Chief Justice. They were peers, both in actual age and date of appointment to the bench. I handled Conchella. Again, all the 5 judges that were empaneled to hear that matter were peers in actual age and date of appointment to the bench. But fundamentally, the benches were balanced. There were 3 male and 2 female. They were fairly senior judges and other judges of recent appointment. And the Rigathi Gachagua case, the Court of Appeal emphasizes that the empaneling of a bench of judges is not a lottery. It's not a mechanical exercise. It needs to take into account fundamental considerations. My lords, as I conclude, an application of this kind is one that we advocates never want to make, but we must make because it is a requirement of the law that we need to make this application. I therefore humbly request that you return this file to the Chief Justice so that the Chief Justice can do the correct thing. 1, delegate the petition filed by herself to the Deputy Chief Justice to empanel a bench. 2, to empanel a bench to hear the rest of the 6 petitions in accordance with the principles set out by the Court of Appeal in the Rigathi Gachagua matter and in the Conchella matter. That is my humble request. I rest. Thank you.
Right. Thank you, Manoj. Well, my learned friend has made an application to revisit the issue of the empanelment of the bench. It has to be taken from the perspective that the issue of empanelment was arrived at.
Lord, if I may, I think it is.
Oh, sorry.
Sorry.
Yeah. Sorry. No, I think I'm wrong. I think those who are supporting Manuel friend ought to start before we respond. Yeah, I thought it was my turn, but it isn't. So those who are supporting the case of Manuel friend can come.
So before the reply, that the opposition, those who are supporting it, maybe can indicate so that we can put the record. Or they are not opposing, they are just leaving it to the court so that we can be able to know.
My lord, I think from the submissions that have been filed,
Yes.
it's only the 14th and 15th interested parties who are supporting Mr. Havi's position.
Who are doing
14th
what?
and 15th.
Who are doing what?
Sorry?
Who are supporting?
Yes.
14 and 15.
Yes.
Your Lordships, in the matter,
Yes.
Miss Mulwa.
Who?
Miss Mulwa.
Mula.
Yes, I hold brief for Senior Counsel Ahmed Nasir.
Ma?
I hold brief for Senior Counsel Ahmed Nasir Abdullahi
Yes.
for the 14th and 15th interested parties. Yes, I confirm that we filed our submissions in support of the first interested parties application.
Yes.
However, we will not be highlighting, we will be adopting our written submissions as is.
Yes, so number 14, the interested party, they are not highlighting, but they are posting the application, they have found submissions. That is the position.
Yes.
Okay, number 15. So, which other party is on that same side? Mr. Murugu, you said 14
It was 14 and 15.
and
Kemboy, my lord.
15. Who was
Kemboy, not Murugu.
yes, where are they?
Yes. Those are the ones.
Oh, this
She
is
out.
15.
Yes.
Okay, so 14 for both of them.
Yes.
Ah, sorry, I didn't get 14. So then we go back to the applicant. So the applicant who are opposing it in the application, in the main application, petitioners who are opposing the application of Mr. Havi. Mr. Uraro, are you the one starting
Yes,
from the opposition side?
Yes, I'm the one. The first issue is the issue as to whether there was the Chief Justice could not empanel the bench because she had an interest on the matter for which the empanelment was being carried out. My lords, what I would like to say in respect of that,
First, confirm you filed the submissions and the reply to the application.
sorry, my lord.
I'm asking whether you filed a replying affidavit and also submissions.
Yes, my lord. My lord, we
And you have
filed
them.
a ground of opposition.
Grounds of opposition.
Yes. And we filed a ground of opposition on 27 June 2025 and written submissions on 11th of July 2025 in opposition to the application. Now, with respect to that, we would wish to say that the issue of whether the Chief Justice can empanel a bench on a matter where she has an interest was settled in application before my Lord Justice Mamuye on 11th April 2025. And Justice Mugambi on 25th April 2025, both of which were served on my learned friend. And the court went into the issue and made a decision. And what you are being asked is the first issue I would like to deal with, which is that the application before you is incurably defective. And that is because these matters had been decided, and the only route available to my friend was either to apply for review or appeal, neither of which he has done. He cannot now come by way of requesting this court by an application to place the file before Justices Mwilu and Justices Koome to deal with matters which allegedly they are not involved in. That is number one. Number two, there is no distinction between these two petitions. They are all both concerned with the direction given by the registrar and the order of the Supreme Court, on which all the judges of Supreme Court are concerned. So to try and purport to make a distinction between them and say that in some, only the Chief Justice has an interest, in others, only the Deputy Chief Justice has a different, an interest, is a distinction without any base.
So DCJ is also a party.
The DCJ is Rosanna has filed a claim
Yes.
on the basis that the Chief Justice, as the head,
Yes.
should have directed the court. So it is on a representative capacity.
Yeah.
And on the other issue of the individual judges have filed their own petitions. They're the same petition dealing with the same issue. And you cannot now, by this game of numbers, put one before the Chief Justice and the other before the DCJ and say they're being decided by people who have no interest, because they have interest in both of them and they're dealing with the same issue.
So the argument that here is that DCJ ought to have taken the one for CJ and CJ do the rest.
Yes,
That's what you get to be the theory of Mr. Havi
yes,
in his argument.
exactly.
Oh.
N-
Mr.
number-
Havi, you reply to that.
Very.
Proceed.
Number three. Rigathi made it very clear that there are only three circumstances on which the constitutional power granted to the Chief Justice to empanel can be delegated. And that is found at paragraph 149 of the Rigathi decision, paragraph 150, and paragraph 152 deals directly with matters where the Chief Justice is directly involved in a matter. And it says, so what happens when the Chief Justice is, for whatever reason, absent physically or temporarily incapacitated, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party or substantially relates to the office of the person of the Chief Justice. In this day and age, we do not think the Chief Justice can be electronically absent for an inordinate long period of time, such that she cannot empanel a bench or give appropriate direction. And they go on, go further to say at paragraph 155 that the decision hinges on rationale that since the function of the Deputy Chief Justice are in the nature of General Deputy, then the holder can undertake any of the functions of the Chief Justice because the General Deputy executes all ordinary functions of the office. We agree, but add that the Deputy Chief Justice can only exercise the extraordinary constitutional administrative functions of Article 165(4) in the exceptional circumstances we have set out, and the existence of those circumstances must be demonstrable and communicated not just to parties in the dispute, but the public. And this was where the Chief Justice is temporarily incapacitated, or when she is absent on leave, or when something happens to her. The circumstances which are outlined in Section 5 of the Judicature Act, which are not in this case. So it is beyond peradventure that this opportunity minority is trying to seize on is not available. It doesn't fall within those exceptions. Now, the next issue is, can DCJ empanel a bench in the circumstances of this case? In this case, you have made a decision on empanelment. You are being asked to review it without an application for review, and to go back and direct the Chief Justice to empanel another bench and DCJ to empanel. There is no provision for such an activity under the Constitution. Now, the issue, he has dealt with the issue of recusal, and is asking your lordships to recuse yourselves. One, because you issued a conservatory order in the first place. Secondly, that Justice Bahati Mwamuye and Lawrence Mugambi were appointed during the tenure of the Chief Justice in a constitutional body called the ASC, and therefore the implication is that everybody who has been appointed during that tenure is beholden to the Chief Justice and ought not to hear any matter she's involved in. And then third, that the empanelment did not consider diversity and regional balance. And lastly, that your lordship lack specialization, seniority, and experience. The Chagwa case did not purport to set up a standard under which the power granted to the Chief Justice can be exercised under Article 165(4). In fact, I will read the particular passage where they dealt with the issue, and what they said is they were speculating on what may go into the Chief Justice's mind. What may go into the Chief Justice's mind when empaneling, not what she's required to do. No, they say at paragraph 133, they start on 133, that on his part, Mr. Nyamodi asserted that during empanelment, the Chief Justice does not receive submissions from the parties regarding which judges should be empaneled. That the decision on which judges to assign is made independently and without input from litigants, reflecting the administrative discretion of the Chief Justice. And then they said, we can think of some consideration that may weigh on the Chief Justice in appointing judges to an expanded bench. And that's when they go to expertise, specialization, diversity, and other issues. It was not a determination of what must be considered and is now being put to you. This case is completely different from what is expressed in the case of Sussex or in the case of Justice Caulfield in Gibraltar, where Justice Caulfield decided to sue an interior minister on a matter where he was the Chief Justice, and they thought that was something a judge should not do. Here, the Chief Justice is expressing her constitutional right to come to court when there is a violation, which is available not only to her, but to every other Kenyan. There is no requirement either under the Constitution or under any law that any bench of more than one judge must take into account the gender balance. It's constitutional. In fact, there are many benches sitting from time to time. I appear in the Court of Appeal quite often, where there are only ladies. Are those benches illegal? And can you recuse yourself merely because you do not think that there is representation of gender, or that diversity among communities in Kenya is not taken into account? I would like to refer you just to the authorities. I wish your lordship to take into account. Lord, I first started with dealing with the issue of functions official, and on that I would like to refer you to the case of Raila Odinga and IEBC, which is in my list of authorities. And you will find it at page 51 of my list of authorities, particularly paragraph 18 and 19. I would like also to refer you to Gachagua on the right of and discretion of the Chief Justice in empanelment, and refer you to paragraph 55. Lord, I would also wish to say that the grounds which have been stated to you upon which you are required to recuse yourself are grounds which do not satisfy the threshold for recusal. And I would like to refer you to the case of Jasbir Singh Rai and Kalochan Rai. You will find it at pages 111 and 158 of my list of authorities. And Gladys Boss Sholei versus JSC, pages 175, paragraph 27. This court cannot permit itself to be placed on unfounded basis or bias to disqualify itself, because there is nothing which is inimical to the rule of law as allowing unsubstantiated application to undermine the functions of the judicial proceedings. Here, you are being tied with the fact that just you are appointed and nobody else appointed except the GSE. You are therefore beholden to whoever is one of the presiding officers of GSE. Nothing can be so foreign in judicial proceedings as what is being claimed in this case. In conclusion, my humble submission is that the application is unmeritorious, speculative, and is a clear abuse of process. And requiring your lordship to follow a path which is contrary to the law, as there is no application for review of the decisions which have been made before you, and there is no application questioning the right of the Chief Justice to empanel under Article 164.5, which ought to have been made if the issue was now to impeach the right of the Chief Justice to have empaneled this particular entry. I would therefore humbly submit that the lordship dismiss this application.
Thank you. Next.
Your Lordship, my name is.
When you sit down, I want you to have no illusion. And this is my fear. I know this application will be dismissed. I said I have an advantage. I know it will be dismissed. I also know the petition will be allowed. But I have no problem with that. What I must do is do what one must do when confronted with fear. When confronted with fear, you either fight or take flight. I've decided not to take flight, but to fight, knowing very well what my eventuality will be. So, without introduction, let me traverse what my colleagues have put as points of law. Starting with my learned senior and good friend, Mr. Oraro, it is true that the decision for empanelment by Justice Bahati Mwamuye was made on 11th of April. And the one by Justice Lawrence Mugambi was made on the 25th of April. He is of the view that I ought to have appealed or reviewed. I'm always very mindful of what President Ronald Reagan said. Those in charge of the system will tell you follow the laid down procedures. In my short life here on earth, I don't follow laid down procedures because I know who are in charge of the systems. But fundamentally, Rigathi Gachagua was decided on the 9th of May 2025. It is the operative law. And it is said where the Chief Justice is a party to a litigation or is substantially affected in litigation, it will be prudent that he or she does not empanel a bench. And this is not said from the emptiness of my head. It is stated from the wisdom of the case of Yakub and another versus the Queen, which you will find at paragraph 22 of my submissions. It's quite clear. And in that case, the Privy Council said it was wrong for Yakub to empanel a bench to hear an appeal from his decision. So if it was wrong for Yakub to empanel a bench to hear an appeal from his decision, it is grievously wrong for Martha Koome to empanel a bench to hear her own case. I fear. My learned friend, Mr. George Oraro, stated that it will be inconsistent for part of this petition to be delegated to the Deputy Chief Justice and part of it to remain with the Chief Justice for purposes of empanelment because they are conjoined.
On 14th November at 10:30 here in open court.
Much obliged, my lord.
Most obliged. Thank you so much.